I call now on Deputy Brian Walsh. You have 20 minutes. I'll let you know when there's 4 to go.
Okay, Garmarkets Cahirlook. Erin Kildal Cheese, Kahim Ra, that there are many elements of this bill that I welcome insofar as they pertain to circumstances in which there is a threat to the life of the mother for reasons of physical illness. It's an axiom of nature and indeed logic that where a dilemma arises involving existing life and contingent life, that the former must always take precedence. At all times in such circumstances, the life of the mother is paramount. This is law, it's established practice, and I welcome the clarity that this bill offers to medical professionals by underpinning those principles in legislation. As a husband and as a father of 2 young girls, I also welcome the reassurance that it offers women that every necessary treatment can be provided to protect the life of the mother where it is subject to real and substantive risk. However, Chairman, I continue to have a number of most serious concerns in relation to other aspects of the bill. Foremost amongst these is Section 9 of the proposed legislation, which threatens to defile our statute book with the absurd premise that the suicidality of one human being can be abated by the destruction, by the killing of another. This principle was conceived not in centres of medical excellence or centres of medical research, but in the courts, where judges are so often faced with tragic human dilemmas that defy the perfections of theory. Essentially, Chairman, hard cases make bad law, and there's no doubt that the Attorney General annexed in all of its heartbreaking detail, which Deputy McKellen has outlined during her contribution, was one such hard case. 2 decades on, the precedent with which it has left us has brought the Oireachtas to the verge of enacting a deeply flawed and dangerous piece of legislation which will undoubtedly make bad law. Proponents of the bill have taken shelter in the argument that we are bound to legislate in line with the precedent set out in the X case. But in a functioning democracy, the role of the legislator must not be to merely codify what is already law, but to challenge existing laws and to debate what in fact should be the law. I believe that it is no slight on the courts or the Constitution to call for a referendum to be held in order to address the incompatibility of certain aspects of the X case judgment with contemporary medical evidence regarding abortion and suicidality. Many have said that the question has been put to the people on 2 previous occasions, and that in fact is the case. However, in the intervening years since the X case, and crucially since the 2 referenda were put to the people, compelling medical evidence and research has emerged affirming that abortion is not an appropriate course of action in the treatment of a patient presenting with suicidal ideation. In fact, the provision of abortion in such circumstances has been shown to result in more mental health problems than it would seek to negate. The development of medical knowledge relating to this area in the period since the X case and abortion referenda is reflected in changes to the UK Royal College of Psychiatrists guidelines, which were amended in recent years in cognizance of the growing body of evidence regarding the increased risk of mental disorders following abortion. The Supreme Court didn't have access to such evidence in reaching its decision on the X case. Equally, the people of Ireland who voted in '92 and again in 2002 operated in an information vacuum regarding the appropriateness or otherwise of abortion as a treatment for suicidality. I believe it is incumbent on us as legislators to make the decisions that we make with regard to the best possible information available to us at any given time. If, for example, we were to frame legislation concerning the health of women in pregnancy based on the best advice that was available, say, 30 years ago, Chairman, we could be looking at providing for symphysiotomy in the legislation. If we were to frame legislation concerning the health of women in pregnancy based on the best advice from a further 30 years back, 60 years ago, we could be looking at providing for the administration of thalidomide in legislation. But we are in the process of framing legislation for the protection of life during pregnancy today, 2013, and we must be guided by the evidence available to us today, not bound by a decision manufactured in the courts in 1992. The Joint Oireachtas Committee on Health and Children provided a forum earlier this year in which eminent representatives from the relevant fields of expertise came before us to present evidence to inform the framing of this bill. I regret to say, Chairman, that it appears that we appear to have wasted their time. Psychiatrists appeared before the committee and affirmed that abortion is not an appropriate course of action in the treatment of suicidal ideation. They challenged the central premise for this tenet of the legislation and were unequivocal that it has no basis whatsoever in medical evidence. Looking at the bill that has subsequently come before the House, it is clear that those psychiatrists were listened to, but not heard. It seems the hearing were a charade, a ploy to preoccupy dissent, and mask the whole process with a veil of complicity and inclusion. Because in formulating the proposed legislation, the government has ignored everything that those experts had to say and has come up with a bill that has been shaped by political considerations rather than medical evidence. In truth, Ken Corla, abortion is no more a treatment for suicidal ideation than suicide is a treatment for suicidal ideation. We're poised here to perpetuate in legislation a fundamentally flawed premise that will be deeply damaging for women and devastating for the unborn. The contents of this bill, so far as they pertain to suicidality, have been hammered out between the parties of government around a cabinet table. And what we have as a result has been decided on the basis of what is best for the politician, the Labour politician in particular, rather than what is best for the mother and child. Section 9 of the bill also threatens to normalise suicide and represents a departure from best practice as outlined in suicide prevention guidelines. We are proposing to codify in legislation the premise that suicide is a legitimate option, the contemplation of which has the potential to make legal something that is otherwise illegal. Suicide is not an option. It is the manifestation of false perception that there are no other options. Our efforts to date in suicide prevention have centred on getting the message out there that there are options. You can seek help, that there is support out there. Our guidelines state that suicide must never be represented as a valid choice. This bill conflicts with that, and it threatens to normalise suicide as a legitimate response to anxiety and distress. If a woman presents with suicidal ideation due to an unwanted pregnancy, and they are granted an abortion on the basis that is the only course of action that can avoid their suicide, what message does that send out to others who are suicidal because of financial pressures or other identifiable causes? Are they to understand, if the material circumstances causing their suicidality cannot be changed, that there is no prospect of them ever to feel better? No less of concern is the absence of a gestational time limit in the proposed legislation, which raises the prospect of gravely troubling scenarios with devastating outcomes for both mother and child. One such scenario is that a pregnancy terminated under Section 9 at 23 or 24 weeks gestation, when the unborn child is on the very cusp of viability. The child may survive the termination of the pregnancy, but being prematurely induced at that stage exposes it to a high risk of incurable conditions such as cerebral palsy, autism, respiratory disorders, perhaps consigning them to a future of institutionalisation and disability. It's not difficult to envisage how a child needlessly damaged like this could ultimately have recourse to the courts arising from the state having failed in its duty of care. The legislation will herald a fundamental shift, to my mind, in the culture of care in Irish hospitals. Our healthcare professionals, in making every effort to protect the life of the mother and that of the child, in accordance with their own guidelines, have made Ireland one of the safest countries in the world for women in pregnancy. But what impact will this legislation have on that culture of care if one day a doctor is striving to save the lives of women and babies, and the next they are gowning up to perform a procedure that will result in the intentional death of an unborn child? There are also legitimate concerns that the legislation as proposed has the potential to affect consequences far beyond the intended remit. Accordingly, the bill has won the support of members of this House who have professed desire to see a more liberal abortion regime than is envisaged here. It is seen as a stepping stone by those members, some of whom we know sit amongst us on this side of the House, And one mightn't agree with the methods that were used to extract their points of view, but we saw very clearly in a front-page article in recent weeks on the Sunday Independent, where two Labour backbenchers clearly expressed that view, that they see this as a stepping stone to a more liberal abortion regime in the future. It has also, during the course of recent months, become apparent to me that many people's understanding of the bill is clouded by misperception and misrepresentation of the changes it affects on Irish law. The tragic death of Savita Halappanavar last year in my own constituency of Galway West in particular has been a lightning rod for such misperception and has been wrongfully used to further one side of the debate. Her case has been cited as an example of why we need this legislation in order to avoid the same fate befalling other women in an Irish hospital ever again. But let's be clear, this bill does not change the law insofar as it applied to Savita's case. Had the gravity of the threat to her life been detected, a termination of her pregnancy could have been carried out under the existing law, as occurs on an average of 30 to 40 occasions per annum in Irish hospitals. That's the evidence we heard at the Oireachtas hearings. But as the clinical review into her death affirmed, a failure to recognise the increasing risk to her life prevented hospital staff from taking the appropriate action in time. Had this legislation been in effect at the time of that tragedy, sadly, the outcome would have been no different. Whether confusion surrounding such matters has impacted on the results of recent opinion polls in relation to this issue can only be the subject of speculation. But I am under no illusion that the stance that I have adopted concerning this legislation is not a popular stance, not a prudent from a political perspective. It's the decision for which I am likely to pay a heavy price. But if political isolation and electoral defeat is the cost of doing what I believe to be right, and in the best interests of the people that I represent, then I would gladly pay that price. Because too often in the past, our decisions have been guided by what's popular, and political foresight has extended only as far as the next general election. It's because of that mindset that we find ourselves in the economic crisis from which we're now trying to recover. It's time for us now not only to look further, but also in a different direction, not towards what is momentarily popular, but towards what is clearly right. It remains my hope that those of us who share these sentiments in relation to this most sensitive issue can be accommodated within Fine Gael. Because there should be no doubt, if the enactment of this legislation occurs with political sanction for those who stand against it, it will not be me or my colleagues who have digressed from our party's values. It will have been the Fine Gael party itself. The party made a promise prior to the last election that it would uphold in government the duty of care to protect the life of the unborn. And based on that assurance of the party, I made a commitment on the doorsteps during that campaign, and that is a commitment that I intend to keep. One senior minister said in recent times of election promises, "Isn't that what you do at election time?" Well, it's not what I do at election time, and it's not what I intend to do here. Given the seriousness of the matters before us and the deep concerns held by a number amongst the Fine Gael Parliamentary Party, I am disappointed that no concession to date has been made available to accommodate our views. This has left my colleagues and I in an unenviable dilemma, in which we are being forced to choose between our careers and our conscience. It is particularly disappointing that dissenting views have not been accommodated, given that there is a precedent in Fine Gael for having done so in the past. In 1993, the party decided to modify the application of penalties for breach of the whip in order to accommodate 3 TDs who indicated that they would vote against the party in support of a bill proposed by the late Tony Gregory to ban hair coursing. The 3 TDs, one of whom was our colleague, Minister Alan Shatter, were allowed to remain in the parliamentary party after they voted against the whip on the bill. Regrettably, it appears that the party will accommodate a vote on conscience in relation to legislation concerning the welfare of hares, but will offer no such, or will accommodate no such vote on legislation concerning the welfare of women and children. It's interesting to recount Minister Shatter's comments during the course of that debate. And speaking in the debate, he said, and I quote, "There is a need for this Parliament, in this Parliament, for us to grow up. There are fundamental issues of economic and social policy which require political parties to impose a party whip to ensure a degree of political discipline and coherence. There are other issues to which the tyranny of the whip, or indeed the protection of the whip, should not apply. If all of the major parties allowed a free vote on issues such as this, governments would not fall, nor would political parties disintegrate. There would be no political cataclysm. The institutions of the state would not collapse. The removal of the whip might also restore some of the general public's faith in politicians." End of quote. Regardless, Chairman, of whether a free vote is granted, I accept that I stand in a minority in opposing this bill, and that it has sufficient support to ensure its passage through the House. I intend to submit amendments to address the concerns that I have raised, and I fully accept that the absurd principle underpinning this legislation will end up where it began, before the courts.
Thank you very much, Deputy.